So, without further ado, I'd like to introduce our plenary speaker, John Paterson. John is a Professor of Law at the University of Aberdeen and a founder member of its Centre for Energy Law. He's worked on a range of international research, teaching, training and consultancy projects in energy law and has published widely on a range of topics in the field. He was recently a visiting professor at the National University of Singapore, teaching international and comparative oil and gas law. He coordinates Aberdeen's contribution to the Advanced Masters in Energy Law under the North Sea Energy Law Partnership with the Universities of Copenhagen, Groningen and Oslo. And he also teaches on Aberdeen's MSc decommissioning programme. And we're very fortunate to have him today as our plenary speaker. So I'd like to invite him to the stage. John.
Thank you very much indeed, Dick, and I hope my microphone is live. You can hear me okay at the back? Yep, that's good. Thanks very much. So, here's the title, Policy, Legal and Regulatory Issues in the Management of Decommissioning of Marine Artificial Structures. Quite a mouthful. And I guess for many of you in the room, you'll be thinking, well, I've been to a lot of these seminars, I've been to a lot of these meetings, and I pretty much know what the law and regulatory position is. And I could, playing it safe, tell you that story again. But I'm going to do something a little bit different, albeit starting with a familiar story. So here's a starter. We've got some key issues that we need to think about before we begin looking at the overarching question. So we often use these words relatively interchangeably: policy, legislation, regulation. What's the relationship between them? Well, generally speaking, we tend to find that we identify problems that we think need to be solved. We make hopefully informed decisions about what sort of solutions we want to introduce, and then we have to make them stick. So then we need to turn them into law. And usually we do that by way of legislation. If we need to have more detail, we'll add in regulation. We'll often delegate the authority to do that to an agency or a department. But then again, policy might reappear, because very often we'll have a policy which will indicate to duty holders how the law and regulations are actually going to be implemented. So these things have sometimes a quite complex relationship with each other. But when we talk about making things stick, we've made decisions about the problems that we want to solve and how we're going to go about it. When we look at legal instruments, we have to be clear that sometimes the law demands things of you. It imposes obligations, it imposes a duty, but also law can be facilitative. It can allow you to do things. Okay? So I want to keep that distinction in mind as well. Okay, with those sort of conceptual things out the way, here is a little bit of an overview of the familiar story, because we're obviously concerned with placing, operating, and ultimately decommissioning offshore installations. And international law at the global and regional level has a lot to say, because we're often working beyond 12 nautical miles, beyond the boundary of the coastal state's sovereign jurisdiction, where the coastal state enjoys sovereignty. We're out beyond that on the continental shelf in the exclusive economic zone, and therefore international legal obligations have a very important role to play. So at the global level, we had, all the way back in 1958, the first instrument to deal with this. We had the Geneva Convention on the continental shelf. And if that was still the only legal instrument in place, this would be a very short presentation, because that instrument gave coastal states the right to go and explore for and exploit the natural resources on the continental shelf. And it also gave them the right to place installations on the continental shelf to go about doing that. But then, critically, what it said was, essentially, and I'm paraphrasing, once you're finished, you've got to remove them entirely. No ifs, no buts, no qualification, take it away. Now, so if that was the position, this would be the end of the presentation. Now, we've clearly still got a bit of way to go, so there's obviously more to say. As you'll know, as time went on, we had a lot of development in deeper water, in more challenging environments, notably, of course, in the North Sea. And structures were put in place during the 1970s and 80s, which really, it was going to be very difficult to fulfill that obligation under the 1958 convention. Think of a large concrete gravity-based structure, a large steel jacket. Not going to be straightforward to take that out in the way that the 58 Convention requires. So what we have during the period of the Third UN Conference on the Law of the Sea, we have states negotiating over a somewhat more nuanced approach. The UN Convention on the Law of the Sea, 1982, therefore, while it still confers the same sort of rights on the coastal state in terms of exploiting natural resources, putting infrastructure in place to do so, now doesn't require complete removal. It's more nuanced. It's about removing with a view to ensuring the safety of navigation and also having regard to other users of the maritime space. So all of a sudden, the opportunity is there, the possibility is there that infrastructure, even once we have finished using it, could actually remain in place. The convention also refers to guidelines and standards by the competent international organization. In due course, of course, we have the IMO guidelines and standards in 1989, which set out non-binding guidance for competent authorities in coastal states, the sort of considerations they need to have in mind in deciding whether or not to allow infrastructure to remain in place, what sort of processes they have to go through in reaching those decisions. So that's a quick thumbnail sketch of the international global provisions in relation to infrastructure on the continental shelf and its removal. Now, the UN Convention is also totally open to the idea that particularly regional groups of coastal states could get together and actually go further in terms of protecting the environment. They could actually impose more demanding obligations even than the UN Convention itself, provided they're doing so to further the overall environmental protection obligations of the UN Convention, and provided they're not doing things that would otherwise compromise the rights of other coastal states. And of course, as many of you here will know, we have a whole range of regional seas, treaties, conventions, and other arrangements all over the world which enhance and develop the fundamental obligations under the 1982 Convention. Now, famously, of course, in this part of the world, that is a matter for the OSPAR, the Oslo-Paris Convention of 1992. And in particular, of course, we have the impact of a decision under that convention, Decision 98.3, which actually imposes the most demanding obligations in terms of decommissioning offshore infrastructure. Now, we'll come to that, look at that in a little bit more detail in just a minute. But in all of this, it's important to bear in mind, and I don't need to tell this audience here or online, that essentially our overarching concern in all of this is environmental protection. We'll find in all the conventions and arrangements that I've mentioned, and others beside, like the London Convention, the 96 Protocol, and so on, that there are overarching obligations to protect the environment. And everything else is essentially about filling in the detail for how we do that in relation to particular activities. Okay? Now, unfortunately, and I regret it very much, I wasn't able to be here yesterday. I understand from the conversations this morning that it was an extremely successful day, a lot of very good discussion. And I think clearly a lot of the things that were being talked about touch on this question of what we do about marine artificial structures when we're finished using them for their original purpose. Are we going to remove them in their entirety? Or are there any circumstances in which we might want to leave them in place? So what I'm going to do now is develop the kind of traditional story that I've told you so far by looking in a little bit more detail at some of the instruments I've mentioned and one or two others beyond. Now, unfortunately, as a humble lawyer, my slides are always really, really dull. I don't have any nice diagrams or pictures or photographs to show you. There's just text. And you're going to look at them and think, these are a bit text-heavy, but bear with me because I will talk you through them and I will point out some of the key terms that I want you to bear in mind. Okay, so just managing expectations there. So, here's the OSPAR Convention 1992. Article 2.1a. Let's just take a look at that. The contracting party shall take all possible steps to prevent and eliminate pollution and shall take the necessary measures to protect the maritime area against the adverse effects of human activities so as to safeguard human health and to conserve marine ecosystems and, when practicable, restore marine areas which have been adversely affected. And that's my emphasis, of course, in there. Now already, just reading that one provision, you can begin to see that a lot of the things that we've been talking about, you've been talking about yesterday, maybe appear in a slightly different light. There's a lot going on in that overarching top-level obligation. Okay? It's not obvious in there that complete removal of marine artificial structures is immediately required, okay? Just from that top-level obligation. Okay? So bear that in mind. Now, there's a lot on here, but this is a pretty familiar one. I'm not going to go into this in great detail because everyone here will be familiar with Decision 98.3. A decision, now, in different settings, you will come across different terminologies when we're talking about legal instruments. In the context of the OSPAR Convention, a decision is a binding element. So if that formulation is used by the contracting parties, then it is binding upon them. Okay? So it has the same status, essentially, in terms of its bindingness as the convention itself. And what that does, of course, and everyone here knows, it is a product of the aftermath of the Brent Spar case in the middle of the 1990s, where a very significant backlash against the decision to allow deep water disposal led to a reversal of that decision and ultimately to modification of international law at the regional level. So right at the top of that, the dumping and the leaving wholly or partly in place of disused offshore installations within the maritime area is prohibited. And again, the emphasis is mine. But then, of course, we've got the derogation categories. And again, that's a recognition of the fact that we have infrastructure in place, but it's actually just going to be technically impossible to move, at least for the time being. So those derogation categories, broadly speaking, are concrete structures, the footing of large steel structures, and again, with thresholds defined, and then in exceptional circumstances. If heaven forbid a structure were to be damaged in an accident and that made it difficult or impossible to remove, again, a derogation would be possible. But these are not given. It's a possibility. You can apply for a derogation. It's then a matter for the competent authority in consultation with the other contracting parties to determine whether or not to grant that derogation. Okay? Now, what this is often read to mean is that unless your disused installation falls within one of those categories, there are no circumstances in which it is going to be allowed to stay in place. Okay? That's fairly standard from the textbooks. I'm going to argue slightly differently, as we'll see. When people are talking about these things in a legal setting, having talked about the international legal obligations at the global level, at the regional level, having looked at Decision 98.3, they'll often then talk about, well, if you are thinking about an artificial reef, we need to look at what OSPAR in this part of the world has to say about that. What are the circumstances in which we would be allowed to construct an artificial reef? Now, whereas Decision 98.3 is binding, these guidelines, updated in 2012, are not. They have the quality of, as the name suggests, of guidance. But what tends to happen then is that we look at certain key terms, and you can find all sorts of summaries and discussions of these guidelines in the literature. And what you'll find then is that people will focus in on certain key terms. Now, back in the original version, you would see artificial reefs being built from natural materials. That's been modified to inert materials. And then there's specification about what that means for the purposes of these guidelines. Inert materials are those which do not cause pollution through leaching, et cetera, et cetera. Okay. And then people will talk about, well, hang on a minute, we've got inert materials in oil and gas infrastructure, for example, but equally in offshore wind infrastructure. Could we use concrete or steel? Well, Materials used for the construction of permanent artificial reefs will of necessity be bulky in nature, for example, geological material, concrete or steel. So on the face of it, we have this sense that given that we've got concrete and steel structures, maybe we could make use of that. But as we know, the guidelines seem to close the door to that insofar as they go on to say no materials should be used for the construction of artificial reefs which constitute wastes or other matter whose disposal at sea is otherwise prohibited. And again, in all of that, the emphasis is mine. So what tends to happen in the various commentaries and discussions that you'll read is that people will say 98.3 pretty much closes the door outside of those derogation cases, and the artificial reef guidelines close the door even more firmly if what you're thinking of doing is based on the idea of an artificial reef. Okay. Moving on, there are other elements of the guidelines that it's worth paying attention to. So if we look at paragraph 7, an artificial reef is a submerged structure placed on the seabed deliberately to mimic some characteristics of a natural reef. It could be partly exposed at some stages of the tide. These guidelines address those structures specifically built for protecting, regenerating, concentrating, and or increasing the production of living marine resources, whether for fisheries or nature conservation. This includes the protection and regeneration of habitats. But the guidelines address those structures specifically built for that purpose, not structures that we might want to leave in place for that purpose. So these guidelines, to some extent, we could argue, don't really apply to the sorts of things we're talking about in this context. And then the authorization for the creation of an artificial reef should identify clearly the purposes for which it may be created. Okay. Now, Decision 98.3, Article 1, defines a disused offshore installation, because remember, that's the term that is used in 98.3 in the overarching prohibition. Disused offshore installation means an offshore installation which is neither serving the purpose of offshore activities for which it was originally placed within the maritime area, nor serving another legitimate purpose in the maritime area authorized or regulated by the competent authority of the relevant contracting party. So, what I'm arguing, tentatively, is that if we actually read these key documents carefully, as opposed to simply repeating the well-understood and often retold story of the situation that the law ends up in, it would seem to be the case that it would be possible, legally, for the competent authority of an OSPAR contracting party to designate, for example, a disused structure, a structure we no longer require for its original purpose, oil and gas, for example, designated as an artificial reef or something else, some other term which I'm sure everyone here is much more qualified to come up with than I am. But something, for example, that is about preserving a functioning ecosystem or something like that. Because that would mean that it's no longer disused, it is actually repurposed. Now, again, as many will know, when you are at the stage of ceasing production, let's say from oil and gas installation, you will be entering into conversations with the competent authority. You will be thinking about the decommissioning process. And one of the things that you have to do, again, consistent with OSPAR, is to demonstrate that whatever decommissioning option you want to put forward for approval, that has emerged from a comparative assessment, and equally that you have ruled out the possibility that there is any feasible reuse purpose. So it would seem to me, and I'm arguing tentatively, that it wouldn't be impossible for someone to say there is a reuse purpose for our piece of infrastructure which relates to preserving a functioning ecosystem, for example. It would then be possible I would argue, for the competent authority to specify that that is a reuse purpose and for the infrastructure to be left in place to that end. Okay? And that doesn't seem to me to contradict anything that we've looked at in terms of OSPAR or Decision 983 or the Artificial Reef Guidelines. Now, some people may find that an attractive possibility, others will find it much more problematical. In all of this, scientific evidence will be fundamental. As a simple lawyer, it's not for me to make that kind of call, but as a simple lawyer, I do have a very profound interest in the rules that we actually implement being based on the best scientific evidence. There is something problematical if the law is imposing obligations which are not backed by the evidence. That is a very problematical situation indeed. So that's the first thing I would say. The second thing, of course, is to acknowledge that even if I'm right, and it's arguable, even if I'm right, and that were to be a possibility, all kinds of other questions would remain to be answered. Who is going to retain or take title to the infrastructure? Who is going to be responsible for it in perpetuity? Is it even possible to think in terms of such a structure being left in place in the long term? Are there going to be other detrimental effects? Are those effects that can be mitigated, or are those effects so problematical that even if this were to be legally feasible and backed by current evidence, we might nevertheless want to turn away and do something different, go back to a straightforward removal situation? These are clearly well beyond my pay grade. Okay, so I think I had a little bit more time available than I was expecting. But I think the key thing in all of this as we go forward is to keep in mind not what we think the law says, but what the law actually says, and to be clear about what the law requires us to do as opposed to what the law allows us to do. Okay? Now, one last point, just to reassure you that I'm not totally naive. It's one thing to say that we could legally do something. It's another thing to say that it could be done on the basis of sound scientific evidence. But ultimately, as our experience in decommissioning shows, what is legally possible, what is scientifically possible, may not be socially acceptable. And therefore, I would fully anticipate that were one to make this argument, were one to come forward and say this is something we want to do, other contracting parties in OSPAR may take a very different view. Okay? So, some food for thought. I'll leave it at that. Thank you very much.